This is what they say. Viewed as a whole, the information presented to the panel, it's not them, prima facie establishes that there was a deliberate intention. So the word prima facie has been used throughout by the panel.
It has. But the earlier portion that I read to Justice Colopin is an earlier paragraph where they're explaining what they understand by that.
Now let's look at that.
Yes.
You and I as lawyers. If the panel uses the word prima facie and sufficient evidence interchangeably as if these were synonyms, that is wrong. Forget about what Makwakwa said. My brother Majid has taken you through what Makwakwa said.
Yes.
That is wrong. And if a wrong test has been applied, it invariably would lead to a wrong conclusion.
Yes.
So isn't the case here that the report has to be impugned because it is based on a wrong test? The panel conflated the two tests as if it's one and the same thing.
Yeah.
You and I know that it is not. We have to search through the report to find the word sufficient evidence to save it. This is a report by 3 eminent lawyers. Do you have an answer to that?
I'm not going to repeat my submissions that you've heard already on the issue of the threshold. But I think in the way you've constructed it to me, I accept what you say, Justice Mathopo, subject to that caveat.
Just to remind you, this court in State versus Tuta, a judgment written by Acting Judge Unterholter, in which my brother Kolapen also wrote a minority judgment. There was a misunderstanding or a misapplication of the test. And as a result of that incorrect application of the test by the trial court, it came to this court, the conviction and sentence was set aside.
Yes.
And if that's the case, then Tuta is against you, number one. 2, you know the tests in criminal law, it's proof beyond reasonable doubt. If a court convicts on a balance of probabilities, the test has been incorrectly applied. The examples are myriad. So even in this case, the fundamental or the fundament of the report by the panel is just wrong. It must be called for what it is.
Sorry, Justice Mathopo.
Do you agree or you don't?
I disagree on the basis of what I read out earlier, because the risk inherent in what Justice Mathopo is positing to me is what I would respectfully say is a form of a substance error potentially. Because what the panel says is the panel in its mind, and based on that earlier paragraph that I read out, which if I can get it, it will be helpful. But based on the earlier paragraph that I read out, it's not that they were thinking about two separate things. Even though they might have used prima facie evidence subsequently in the report, what they continuously tell you insofar as how they understood the meaning of that is that's related directly to the evidence of justified only when sufficient evidence exists.
But look at the conclusion that I've drawn your attention to when I first started my question. It says, viewed as a whole. In other words, in conclusion. That's what they're saying. They've nailed their colors to the mast. But that's what they're saying. Forget about how they took the journey or they undertook the journey.
Well, I think that puts me in a difficult bind because it asks me only to consider what they say in the conclusion despite what they give earlier, which adds color to that conclusion, which is the paragraph that I just read out. I mean, if I have to ignore that, then the way in which Justice Mathopo presents it to me is unanswerable, but I would say that that is at the risk of the form of a substance issue because of what they say here at para 76.
Are you prepared
75?
Are you prepared?
No, it's 76.
Are you prepared to accept that at the initiation of the complaint, there has to be a prima facie evidence?
Are you talking about, Justice Mathopo, when it goes to the Speaker?
Just at the beginning, initiation.
I accept that.
And are you prepared to accept that when the panel conclusion has to be based on sufficient evidence or both, or it doesn't matter?
Well, based on what I read out, it doesn't matter because they've equated it to the same thing. Substantively, even though they're calling it prima facie evidence, that the test and the threshold which they themselves are seeking to answer is as set out in that paragraph, which is sufficient evidence exists for the President to answer a case.
Okay, let me wrap up and move on to something else different briefly. What I don't understand is why the applicant did not directly and frontally challenge the rules. One, the relief that has been sought, the resolution that was taken in December, and everything that goes with it. The ship has left, has sailed out. If the EFF had challenged the rules and asked for an amendment before the National Assembly, wouldn't that have been a prudent move to do? Short of lumping the whole thing with what it has done now?
No.
I'm bringing into question the issue of delay, mootness,
I hear you.
prematurity.
No, I hear you. That would only be competent vis-à-vis the attack on the rule, but then it would still leave the substantive outcome of the National Assembly's decision and what is to be made with that. So the EFF is in the court because it says that's the exclusive jurisdiction issue, and because the decision that was made and which is being impugned is in terms of Rule 129, that invites it and this court then to consider the competency of the rule as it is now constitutionally challenged in front of this court. The EFF's case is not only about the rule. If it was only about the rule, then I think Justice Mathopo's observation is correct. Maybe it should have gone in the High Court and started there and attacked the rule or whatever else.
Yeah, but how good is the EFF's case in respect of the other prayers? I mean, let's look at it practically. What is it seeking to do?
It's seeking to get...
I mean, if it goes to the rules, it's something else. It might have a case to sustain. But all the other reliefs, I don't know. Hasn't it misconceived its position? Just think about it. Move away from the issues and look at the practicalities. And take a step backwards and look at the issues. What is it that the EFF seeks to achieve? The EFF seeks an amendment to the rules. Its complaint is not what happened, because the boat has sailed. Its complaint is the rules as it is now gives us a problem. That's where the problem is. No other problem. All of these things are just lumped